Now, what do we do to protect ourselves against these issues? Well, the open source community has actually been quite lucky, I think, to not have suffered an attack like what SCO has brought sooner. Possibly one of the reasons for that is that the open source community generally doesn't have very deep pockets to satisfy a court judgment, so there's not much point in suing open source developers. And also the fact that a lot of open source software, there's no one obvious to sue. Like in the case of the Linux kernel, there's thousands of copyright owners, and the question is, who do you actually sue? So we have been lucky, but although this is the first significant legal attack that we've had to suffer, I don't think it's going to be the last one. I think we do have to acknowledge that there are problems out there. Just taking an example, in the Linux kernel, there's undoubtedly patent infringements there. I mean, there's no question that there are. And probably the patents that are being infringed are held by people like IBM, ironically. But we are lucky that there's a lot of goodwill out there in the community, and that there hasn't been a concerted attack on the kernel for patent infringements or anything like that. And it's not just the Linux kernel that's had that good fortune. Even proprietary projects out there undoubtedly infringe patents but aren't being attacked on that basis. So. But we do have to look hard at what lessons we have to learn from the SCO case if we're going to protect ourselves against future litigation of this type. And there's several ways that we can try to protect ourselves. The Chinese walls, what that actually means is for those who wish to work on proprietary projects and open source projects at the same time, a Chinese wall is like an invisible barrier that goes through the middle of a company that tries to protect each side from the confidential information of the other side. So it's just like a barrier to stop confidential information getting through. And that's what IBM claims to have done between its AIX developers and its Linux developers. Now, will this wash? We don't know for sure, but I think if it's been done properly, it can wash. It's a risk, but IBM is not stupid. And I think if you're a smaller developer, you've got to sort of emulate what IBM's done in that respect. If you're going to take on the risk at all, you've got to make sure that there is a real separation there so that confidential information can't flow through. I think you don't want to have to face that sort of argument in court if you can avoid it. So ideally, don't work on proprietary and open source projects that are in the same field at the same time, because if you do, you're asking for the argument to be made against you that you've allowed confidential information to pass through. And a Chinese wall is not the best solution. The best solution is just don't put yourself in that position to begin with. Okay, the next thing we do, it may sound mercenary, but I think the best protection for an open source project against liability is to make sure that the developers are the ones who have the liability on their shoulders. And really, I mean, that's only sensible, because the developers are the ones who can have the best idea of whether their code is contaminated or not. You know, they're the ones who are writing it. They're the ones who are in the best position to check it for intellectual property infringements. So what you can do as the leader of an open source project to ensure the cleanliness of the code that's contributed, you should get the developers to agree in writing that all the code that they do contribute has either been written by them or has been taken from a source that's in the public domain or has compatible license terms. And if they do take some code from another source, you need to document that, put it in a register, say this is what we took, this is when we took it, and this is the license under which we've taken it. Yes? Well, I mean, whether you actually ask them for an indemnity or not is a bit of a judgment call, because these people often are doing this for free and they don't want to have to sign an indemnity saying, yes, you can sell my house if you get sued. So, yeah, that's a judgment call. I think you're not necessarily getting them to sign an indemnity, you're just getting them to sign on the dotted line so they take it seriously. Whether it actually contains a legal indemnity in there, maybe that's going too far. It really depends on the project, but often that will be going too far and it'll scare people away. Obviously, you don't want to scare people away. Yeah? Defamation, no. Probably not, because anything that's said in the course of court proceedings is protected. But yeah, if you've paid licence fees and it subsequently turns out that they didn't own what they were purporting to license to you, I mean, I haven't seen the terms of their licence agreement, but I would imagine that you could have a claim for a refund, yeah.
The reason why I was asking about defamation, not what actually is going to happen in the court case, but the fact that they're running around at the moment, basically saying if you're using this, we're going to come after you.
Yeah, it's not so much defamation, but I think that is exactly where Open Source Victoria is coming from in their complaint to the ACCC. They're saying that SCO is engaging in misleading and deceptive conduct. I think that's pretty much where you're coming from, yeah. So that's an argument, yeah. So it's not going to, even if SCO, well, I mean, SCO's not going to win, but no matter how SCO, no matter how SCO comes out of this, it's not going to go away on the 23rd of February, or 11th of April, sorry, 2005. Yes, one more question for now, yep. Yeah, I mean, they can require corrective advertising, that sort of thing. Maybe a full-page ad in the Australian saying there's no problem that we can prove with the Linux kernel. As far as we can prove, you're entitled to keep on using it, something like that. I don't know. I'm not involved in that. I haven't really spoken to the Open Source Victoria people about that. The other thing that you should do with your developers is get clearance from their employer if they are employed by someone else on writing software. You should get clearance from their employer to acknowledge any non-disclosure agreement or any confidentiality duty that they may have, and get clearance to allow them to work on your project. And examples of these kinds of agreements, examples of these kinds of agreements and acknowledgements and stuff like that can be found in some of the larger open source projects, such as the GNU project and Mozilla and OpenOffice.org. And so you're really reducing your risk of liability if you do get them to sign something, just to acknowledge that they do have obligations there. And you've got to make a judgment call over whether you're going to scare them away or whether you're going to actually give yourself a bit of protection against liability on your own account, because you're the leader of the project and you're the obvious person to sue. Yes? SCO, you mean? Yeah, certainly. There's not a requirement for one country, for Australia, to follow decisions of the United States. It is going to be persuasive if the United States court makes a finding of law, not so much a finding of fact, but if they make a finding of law, then that's not going to be completely irrelevant in Australia, but it's going to be largely irrelevant because particularly our High Court, they don't take too much notice of what any other country does. I mean, it's got some... If it was a line ball decision, it might make a difference, but it's not going to be a line ball decision, so I don't think that it's going to make that much difference.